All right. Thank you all for coming. I really appreciate it. This is maybe a little bit out of character for the rest of the conference, but we think it's a fun and very useful talk. So my name is Pierre Bradley, and I'm currently the Director of Online Strategy at UC Davis.
And I'm Mary Minow. I'm a library law consultant, and I'm currently an affiliate of the Harvard Berkman Center for Internet and Policy.
So today we want to talk a little bit about an area of net regulation that we both feel is really important, but is probably a little less covered than either of us would like for libraries and publishers, and also archives and museums and other public sector institutions. And that area of regulation, in some ways, is a flip side of copyright and DMCA, which we'll mention again later in the talk. But this area is that we'll be addressing today is increasingly present in the press, and you're going to see, I think, even more references to it in the future. And it's about free speech. And free speech is obviously important to both libraries and publishers, but it's something we haven't really had to consider much in the past. And we're going to have to consider it more. And we're going to talk a little bit about why that is and what the trajectory may be for network regulation in this space. So the concern about the contours of what's acceptable speech on the internet became a topic of discussion before the internet really came into being. The moment that bulletin boards started becoming fairly prevalent and enticing a large number of users to engage on them, a debate about what kind of speech and what kind of discussion should be prohibited or censored on these kinds of platforms immediately arose. And if you think quickly about the development of new forms of media, technologically enhanced media, from the 20th century onwards, there have always been these debates. So if you think about the development of radio or TV, these are media communication channels that are relatively tightly regulated in terms of what kinds of speech are okay or prohibited, what kinds of activities are permitted to be shown, and so forth. That loosened up a bit with cable TV, and then with the internet, there was, at least initially, very little regulation over what was accepted speech. But as I mentioned, there's always been these debates about what's okay or what might be considered inappropriate. And this cover that's on the screen right now is a cover from a 1995 Time magazine with the title Cyber Porn, with a horror-stricken young child who clearly is aghast at what he's finding on the network. And the debates over sexual expression on the internet occur over and over again, and they drive a lot of the regulatory machinery in debate. And I think it's not pulling too many punches to note that the other area that triggers a lot of these debates happens to be areas of or around defamation. A person saying something bad about another person, or more likely a company, and the company taking offense and wanting to take action against the party who made an allegation. And so in 1995, there was a great debate about whether or not the kind of speech that we dealt with in radio or TV, that those kind of protections might be moved forward. And then ultimately, they didn't. And the internet was left fairly free until this year, actually, in many ways. For the first time, several actors, here you'll note Craigslist, had to actually take down some significant communication channels, in this case personals at Craigslist, because of the passage of a law called FOSTA. Now, FOSTA was intended to combat sex trafficking on the internet, which is a noble aim, but it was written in such a way that it had a slew of unintended consequences. And one of these was that Craigslist actually had to protect itself by taking down major forums for communication. It had other effects as well. So what we're going to be talking about today is this segment of law that actually served to, in many ways, protect speech on online platforms, called Section 230, and discuss how those protections came into place, how they were threatened with reversals, and then how we entered a long period where there was fairly static understanding of what was acceptable speech on the internet. And then now, with a sudden uptick in a wide range of network regulation that you're starting to see more and more often in Congress and in other major forums today.
I'd say that Congress has never seen a piece of anti-porn legislation that it didn't like and vote on nearly unanimously. So so we're going to start with the wondrous win if you are on the side of open online platforms. How many of you remember CompuServe or Prodigy were actually members? Okay, bit of an older crowd. The 1991, CompuServe was the place to go to get content, perhaps post little content, and then Prodigy came along soon thereafter as somewhat walled gardens. They weren't the platforms that we have today, but that was what there was. In a court case against CompuServe on a defamation charge in 1991, Cubby, who had a broadsheet, who had a rumor journal, I'm saying journal, newsletter called Scuttlebutt, filed against Rumorville, which had competing one, and against CompuServe for hosting it. And what did the court say? The court said, well, CompuServe is just an electronic for-profit library that contains a vast number of publications, and its subscribers get this information in return for their money. And it was a wondrous, wondrous win because it went on to say CompuServe is not a publisher. CompuServe has no more editorial control over such a publication than a public library, bookstore, or newsstand. A public library, bookstore, or newsstand. That's a phrase that you'll find in hundreds of defamation cases, and every time I see one, I go, ah. Public libraries, bookstores, and newsstands are not on the hook for every bit of defamation that they have on their shelves or on their files. And it would be no more feasible for CompuServe to examine every publication it carries for potentially defamatory statements than it would be for any other distributor to do so, a mere distributor. So a huge win. The internet chugged along for just a few years until stunning reversal with the Prodigy case, where Stratton Oakmont, which is a securities firm that you may have seen in the film The Wolf of Wall Street, sued Prodigy because they couldn't find the actual poster, and said that there was defamation because there was comments saying that they were fraudsters. Well, that's a good moment. Okay. Anyway, the court said, we're going to rule, we don't even have to hear all the facts, we're going to rule for summary judgment against Prodigy, and here's the reason why. Prodigy, unlike CompuServe, which was just kind of everybody come get it, Prodigy actually was a little more family friendly. It claimed editorial control. It had content guidelines. It would actually take off bad words sometimes and use software screenings. And so this changed everything. The court in that case said that it was a publisher. And do we have any publishers in the room? Okay, so publishers have to be concerned. You know, when you're publishing something about defamation, the plaintiff's going to go after the publisher. In this case, Prodigy was seen to be a publisher because it had these editorial controls. Now, Chris Cox, do we have the picture of him? I'll start with the picture. Does anybody recognize who's with Chris Cox here? Anybody from Oregon? Okay, so Senator Wyden, then Representative Wyden, and Representative Cox were our open platform heroes. Chris Cox was on an airplane and he read about the Prodigy ruling and he's like, this is not gonna work, this is gonna, like, you know, choke the internet. And that new internet platforms could not afford the liability or screen all the content. And so the two of them drafted a bill that would explicitly overturn the Prodigy ruling. In fact, one of the Prodigy lawyers helped them draft the bill. So this is our heroes, you hear the music. This is
Did it pass easily?
the return to grace. It passed easily because it was inserted as an amendment to the Communications Decency Act. Does anybody remember that law, the
Yes.
Communications Decency Act, which was an intent to bring it down, the level of the internet pretty much down to the level of children, so that there would be no indecent communications if children could get it. That was authored by James Exon. That passed easily, 424, and this was an amendment. So it was a ship that was sailing. And in fact, it was very ironic because this Communications Decency Act was clearly an intent to restrict the internet, and this amendment ended up exploding the openness of the internet. So if you were around in 1997, I was at this ALA conference in San Francisco. There were huge celebrations because the ALA, the ACLU, sued the federal government saying this was unconstitutional, the Communications Decency Act. The Supreme Court actually agreed and struck down the main portion of the Communications Decency Act, but kept this amendment, this Cox-Wyden amendment, which is known as Section 230. And the key language in this amendment is 26 words long. There is a new book coming out by Jeff Kosseff at Cornell University Press called The 26 Words That Created the Internet. So these 26 words are in Section 230 that says that no provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. So what that's saying is, if you're just a platform, or you will not be treated as the publisher for third-party content. Okay, and interactive computer service is actually defined pretty broadly, and it says such as libraries. So libraries that offer internet service are considered interactive computer services. And in fact, there was a court case on that back when I was in California. The Livermore Public Library was sued because a young boy was able to get porn and print it off the library computer. And the city invoked this. They said, Section 230, we are an interactive computer service, and the court agreed. Now, Section 230 has two parts. One is the part that everybody cites, that you are not a publisher, or you're not to be treated. Oh, I'm sorry, what's your name, the publisher back here?
Oh, sorry. My name's Andrew.
Andrew. So you're not Andrew, okay? You're not going to be treated as a publisher or a speaker. You're good to go. And even part two is, even if you what I call the Prodigy Amendment, even if you exercise editorial control with content filters, you take away some language, you're fine. You're not a publisher. In addition, it prevented states from imposing conflicting law, and there's a carve out for federal criminal law, and a carve out also, I should mention, for copyright infringements. So you are on the hook if one of your users posts something to your site that's a copyright infringement. And that's why, unless you take a few actions, which you will hear about if you stay.
So 230 was an incredibly important clause. Those 26 words really permitted the growth of the internet that we know today. So all of the online forums that you likely use in your daily life, like Yelp or Google, Facebook, YouTube, Instagram, all of them are online providers that allow their users to post content online. All of those providers exist thanks to the protections of Section 230, because without 230, they would have the risk of liability for the content that those users are uploading, and risk significant rulings against them for monetary damages, as well as other potential breaks against federal law. Now, there have been continuous challenges to parts of 230 since it was passed, and indeed, on the screen, I note a recent one called Castle v. Bird, which actually invoked Yelp, even though Yelp wasn't named in the actual suit itself, but called on Yelp to take down some content that was in the subject of this particular case. Yelp was able to refer to 230, and it was clear to the court that Yelp was protected in that particular case. But it's still continually misinterpreted to assume that if a company takes any editorial act at all, that it's somehow waiving the liability protections of 230, and that's not the case. And the arc since 230 was passed through the CDA and the court rulings that have returned the CDA but retained the 230 clause, the courts have consistently protected free speech on the internet. And there's been some moments of stirring language, and in fact, in one of the cases leading up to the Supreme Court ruling, Judge Dazzle wrote, "The strength of our liberty depends upon the chaos and cacophony of the unfettered speech the First Amendment protects." And you see those kinds of protections emerge over and over again, but there have had to be a string of cases that delineate that. So on the screen, I just note a couple of them: Ashcroft versus free speech, Ashcroft versus ACLU. These were from the early 2000s. But even recently, Packingham versus North Carolina is a case that actually protected the rights of sex offenders to gain access to social media for their own purposes of expression. So these are very much vibrant conversations still taking place. But the arguments about sexual expression continued unabated through this time. And even in like 2008, 2009, Craigslist felt forced to remove some of its online forums, like its erotic services and adult services sections. And then in 2011 onwards, there started to be some lawsuits that hit Craigslist and another site, which becomes increasingly important, called Backpage, that alleged that sex trafficking was beginning to take place on these forums. Craigslist even placed a censored bar over parts of its site in protest over the kinds of litigation and issues that were emerging at that time, which was widely covered. But ultimately, Craigslist and some of the other forums were fully back online after they themselves started putting in some self-policing filters and algorithms to try to hold back some of the more nefarious content. But by 2017, what century are we in? By 2017, Congress's level of concern about sex trafficking was ramping up considerably. And in part, that was because the site Backpage had started to be much more open, receptive to a wide range of postings. And some of these were fairly explicitly sexual trafficking or human slavery oriented. There were sort of commercial sexual transactions or sex-related transactions that ran counter to federal law. There were several lawsuits against Backpage. Some of them were successful. But despite all of that background action, which readily invoked existing federal law, Congress, both houses, felt that they had to take additional steps. And so two bills were drafted with roughly similar aims to put a halt to the kinds of sex trafficking that so disturbed legislatures in forums such as Craigslist and Backpage. The Senate's version was called SESTA, and the House's version, FOSTA. Now, the House's version wound up being amended under the advice and advocacy of several internet firms to make the language a little bit better and refer back more strongly to the protections in 230. But as so often happens when bills are consolidated, the worst pieces of each bill were picked, and so a lot of that improved language was thrown away. And so the language that remains in FOSTA is unfortunate and has had unfortunate consequences. Now, the bill was signed with, as I mentioned earlier, noble intent to put a halt to sex trafficking and online slavery and other issues that already ran counter to federal law. But it unfortunately had extraordinarily vague language in the writing of the bill. And this is not what good law requires. Good law requires very clean, careful, delineated language and definitions. But FOSTA includes terms such as promotion or facilitating prostitution and reckless disregard of sex trafficking without clarifying what promotion means. And as another example, if an online provider acts in reckless disregard of the fact that such conduct contributed to sex trafficking, well, what does contributed mean? Again, a very important word left undefined. FOSTA expands criminal law for sex trafficking, and then again in another unfortunate clause defines participation in sex trafficking to include assisting, supporting, or facilitating. In very vague terms. FOSTA expands the exceptions from liability protection that are in 230. If you remember, 230 had a carve out for child sexual acts and other federally prohibited sexual activities. FOSTA also nullifies the state immunity clause, and importantly, it allows low-threshold private civil lawsuits to come forward. So that's important because it's far easier to file a civil lawsuit than it is to file criminal action. So the impacts of FOSTA were immediately. We opened with Craigslist's action of taking down its personals, but they were far from the only one. Reddit also took down several of its channels, and Microsoft, oddly, felt that it had to issue a warning on language that is conveyed through Skype and among users of Xbox games and forums. And oddly, to the, or perhaps bizarrely to the legislatures who were trying so hard to do a good thing, it actually has had a negative impact on sex workers. And the reason is that sex workers actually used these public fora to warn each other of individuals who might be bad actors. So they created whisper networks to warn against individuals who might engage in violence or in other activities that might be degrading or demeaning. And they also use these forums to share health and safety tips, not just about safe sex, but how to pursue safe conduct and how to protect yourself, and who to contact for help or assistance if that's needed. And even district attorneys had actually protested before the bill was passed, because if you were a DA, you could more readily find instances of sex trafficking on the forums themselves than if they were pushed into the darknet, which is what's happening today, now that FOSTA has been passed. And critically, even online platforms like libraries that provide public forums for discussion or debate or engagement are potentially subject now to this law because of the openness that those forums have had to the language that might, under some considerations, be considered as transgressing FOSTA. As a quirk, sex workers are actually mobilizing for themselves, in part because this law has been a protagonist for that activity. And indeed, a couple of individuals that were running in the elections on Tuesday who actually were voted in, Alexandria Octavia-Cortez, Julia Salazar from New York, both actively went out in support of sex workers because of the sense that their abilities to protect themselves have become more threatened under FOSTA. So they were very vocal about having sex workers' backs.
So after this 20-year golden period of proliferation of this really kind of bulletproof immunity that platforms had for third-party content, for user content, things have changed dramatically, and so it's a renewed battle. And the battle is being waged in the court. The Internet Archive is one of the plaintiffs, along with the Woodhull Freedom Foundation, Human Rights Watch, and 2 individuals against Jeff Sessions, the United States of America. So we would want to insert his acting person for the next court documents. That name will be changed. And the complaint says that the language is too vague. So Woodhull and Human Rights Watch are saying that the decriminalization of sex work, it's unclear whether advocacy is facilitating. They're trying to make prostitution legal in other places, for example, outside of Nevada. The Internet Archive, which I think is the most relevant to this audience, is concerned that its archives of websites books and metadata may be interpreted as promoting, and they can't police it all, can't look at everything, or facilitating prostitution. And so I've got the declaration of Brewster Kahle here, who really says this reckless disregard standard, if that speech assists, supports, or facilitates sex trafficking, it's just not workable. And they have 330 billion items, at the Internet Archive. And so this is why Brewster Kahle joined the lawsuit. Just happened, court said, dismissed all of the plaintiffs, the Internet Archive and the others, for lack of standing. Okay, so that's always the hard thing. You have to show that you have a direct hit on you, because the courts don't want to just say, oh, I don't like this law, I don't like that law. So they were all thrown out for the lack of standing, that there was no indication that they have something to lose from the law. So the plaintiff attorneys, Brewster Kahle and the others, have appealed the ruling on October 9th. So we're waiting, who knows how long, for the appeal to be heard by the Third Circuit Court of Appeals. Now, we're going to take just a little side road, because there's two sides of the regulatory content coin. This is Peter's good with the words. So there's the creative expressions, criticism, news, research that we're talking about with the free speech, but the other way to regulate content is through copyright, right? And so you may have noticed that I said that Section 230 also had a carve out for copyright claims. So you're not, as a platform, as a library distributor, you're not immune from copyright claims that come to you by way of your wonderful patrons posting a review of something that they took from somewhere else, unless you file a simple form. So how many of you have done this? We actually made this a handout, because this is an action item. Check to see if your institution has done this, and not only has done this, but has done this since December 31st, 2017. Because the Copyright Office has its own system to protect the platform, the library, your distributor, from third-party copyright claims. But it has to be filed. And you have to file as an online service provider, and when it was first set up, you could file it once and you were done forever. And so you may have closed your eyes and not noticed that they now said, well, forever isn't really forever. We're going to change that, because a lot of these old filings are really dated and incorrect. So, it was really sort of a stupid system in the first place. So now you have to file every 3 years. So check to see if check with your counsel to see if you have already done this, or your institution's done this. And then if you've done it, there's things you have to do. You have to put down who to contact if somebody is upset with you, and how to contact them, and there's certain language you need to use. But the Copyright Office has a good FAQ, which is on here, so you can find out about that.
So the issue we raise, or the reason we raise the copyright side of the coin, is because increasingly the regulatory debates around copyright and the future of copyright regulations and laws, it mirrors in many ways the debates about regulating speech on the internet and what will happen to 230. So as an example of that, in the European Union, recently a revised copyright law was put forward, and the copyright law is actually incredibly contentious, this particular proposal. And primarily for a couple of the articles. One has to do with search engines linking into stories that, for example, newspapers publish, and whether or not there should be any remuneration for that, and so forth. It's called the link tax article. But for our purposes, the one that's really important is Article 13. And the language here has eerily similar overtones to the debates around 230 and the rulings that Mary walked us through earlier. So with Article 13, platforms with large amounts of user-generated content might be liable for copyright infringement by their users. And Article 13 suggests two cures, one of which is the one we've seen over and over again, that if you take technical measures or put into place algorithms to identify copyright violating content, then you can claim some protection from liability. And if you're a small player or not sophisticated technically, we have a solution for you, and it's called collective licensing. Just sign here, pay this fee, and we'll sort of waive your liability for the actions of your users. So it's quite conceivable that if this proceeds, that we'll see a uptick in the kind of collective licensing agreements that have been problematic historically in many areas. This kind of copyright law, just as the Stratton case might have in the US if 230 hadn't moved forward, would have significant damaging impacts. Limits on speech, limits on content serve as a brake on startups or young companies entering the market. It creates incentives for them to narrow their service offerings, and it encourages overly aggressive content filtering if they do move forward. In this particular case, there's quite a bit of dissension from Germany and Italy, albeit in different areas, so it's not really clear what will happen with this law. Again, this is happening today, very current, so you can watch this unfold on the news. And then recently, this rise in the concern about fake news in the United States and in other countries, concerns about manipulation of social media platforms, has engendered a surge of interest in new regulation over internet platforms. And so as the months start marching through, you're going to see the issues we've been talking about today start to rise up again and again. And one of the things that's really concerning is that, as we mentioned earlier, 230 is consistently misunderstood. So when Senator Ted Cruz of Texas was interrogating Mark Zuckerberg of Facebook recently, he said, "The predicate for Section 230 immunity under the CDA is that you're a neutral public forum. Do you consider yourself a neutral public forum?" Well, that is just flat wrong, right? That is a gross misunderstanding of 230. 230 says nothing about whether or not you have to have a zero bias politically or socially or in any other spectrum. Ted Cruz was immediately called out by people who are familiar with network regulation, but this is the kind of mistake that people interested in network regulation have to be concerned about.
So the continuing battle, I mean, after all that grace, is with the pressure from on the platforms to do something to stop fake news, extremist hate speech, all this voter misinformation the last week is very real. And in a world where there's 1,000 private platforms, it should work, but it's really consolidated, right? So we just have a few private platforms that are making these rules. They've been protected with Good Samaritan plans. And Twitter, which was really like the most open, is now actually pulling back and curbing some forms of hurtful speech. They have a draft policy. They want people's comments still, that content that dehumanizes others based on their membership in an identifiable group, even when the material does not include a direct target. Well, this is like the basic nailing the jelly to the wall problem that First Amendment issues always run into. What is content that dehumanizes? There was somebody who tweeted, "I'm not an anti-Semite, I'm an anti-termite."
Quote from Farrakhan.
Farrakhan, that's it, thank you. It's so difficult to determine what is dehumanizing others. It's very vague and hard to define. So in the end, the wild and woolly open internet had a good run with many lasting beneficial changes. And this country has had more innovation than any other, many would argue, because of Section 230. And now suddenly some apparent great costs. So a ubiquitous global network must generate a dialogue. And this is where we leave it for you in the last few minutes to come up and tell us, for corporate, educational, or not-for-profit responsibility, for example, is it time for a nonprofit library academic group to have a platform to provide an outlet for cultural conversation and not rely completely on commercial interests?
And that's it.
Do you have the answer?
So thank you for listening through that. We have just a couple minutes for questions.
Okay, this is a real question related to libraries that came up a few years ago because the intellectual freedom interpretation was going to say that if you had a library discussion list about materials, that they were giving up any possibility of censoring this And I was the person that raised my hand and said, you can't do that. Because then you would be stuck with racially and sexually offensive comments that people might make. What does the law, and so,
What was the context? It was offering up to the community to?
yes, be able to review books.
Oh,
But they were promising that we would not censor them. And I said, you can't do that because you then may find completely objectionable content on your site, which would be protected by the First Amendment, but not stuff that you would want to have connected with the library.
and this is a really interesting illustration of the difference between a privately run library and a publicly funded or run library. Because if you are private, you can decide to
Right.
take off under 230, whatever you want. If you're a government library, then you are subject to the First Amendment. And I would argue very strongly that you have to be very careful not to take off constitutionally protected speech. I know that libraries are doing
Okay,
so.
can you define it as a moderated list, though? Is it possible to say as a public entity that, yes, we're providing this list,
Okay.
but it is moderated and make that clear in the terms of use?
That's a good point. I think the more you make it look like you're actually the editor of a newsletter, and I think the stronger case you have. Like, for example, if you put out a library newsletter and you have letters to the editor, you choose what to put in there. The more you make it look like it's an open, forum, then I think you're creating a public forum, which would subject you to trigger First Amendment liability.
Okay, but it would be possible to kind of try to push it towards the fact that, yes,
Yeah.
it is like letters to the editor, so if we find your letter
Right.
to be inappropriate, we can remove it.
Not only would that be appropriate, but I haven't seen court cases that I would have expected to come against all kinds of government websites that allow content and have all kinds of content policy, like they can't do this. But apparently it's so now entrenched that it's probably fine. But I would wait for that lawsuit. The more you make it look like it's a newsletter with editorial control, the better.
We have time for
Sorry.
one other quick question. All right.
Nothing from the publisher? So just to point out, the publisher is defined as anyone who's publishing. So any commenter is the publisher. So there's always a recourse for the aggrieved party who's to go against who's ever posting. So it's the platform that we're trying to immunize. Yeah.
Just a quick information thing. What circuit is the case that was on appeal? What circuit is dealing with that, you know?
Oh, with the Woodhull case?
Yeah.
I do, but it is the District of Columbia.
Ah, okay. That would be fourth.
I just had the declaration, which is.
Thank you.
Yeah.
All right, thank you all very much for coming.